in so many ways, it is not at all clear to me that the judges actually understood what they were writing about. I will just point out, if you remand it to the FCC for a new order consistent with this decision, it would be as if you were to say, you Army go to war, but we're not going to give you any bullets, no guns, no tanks, but really go fight a war. What are you talking about?
That was Blair Levin, senior fellow at Brookings Metro and former executive director of the National Broadband Plan and chief of staff to FCC Chairman Reed Hundt, about the confusing nature of the Fifth Circuit's recent decision on the constitutionality of the USF program. Hi, I'm Jeff Johnston, and welcome to the All Day Digital Podcast, where we talk to industry executives and thought leaders to get their perspective on a wide range of factors shaping the communications industry. This podcast is brought to you by CoBank's Knowledge Exchange Group. The Fifth Circuit recently issued its ruling on the claims made by conservative group Consumer Research that the current USF program violates the Constitution. This ruling is a head-scratcher, even for policy experts like Blair, and it's unclear where we go from here. Blair is one of the most knowledgeable and experienced telecom policy experts in the country, so I was thrilled when he agreed to share his thoughts on how we should think about this ruling. So, without any further ado, pitter-patter, let's hear what Blair has to say. Blair, welcome to the podcast. It's an absolute pleasure to have you back on. How you been?
I've been fine. Thank you very much. It's a pleasure to be back.
Wonderful, wonderful. Well, our timing couldn't be better to have you on to talk about an incredibly important topic, and that is USF and the challenges that we've seen in the courts regarding the constitutionality of USF. And there just so happened to be a ruling yesterday from the Fifth Circuit, something we've been waiting on for quite some time. Having you here the day after to discuss it is wonderful timing. So maybe, Blair, you could just kind of give listeners a high level on what happened yesterday out of the Fifth Circuit in terms of, their ruling on the constitutionality of the USF program.
So there's a conservative group called Consumers Research, which has been involved in a lot of litigation challenging regulations of all kinds. And a couple of years ago, they filed in 4 different circuits a case arguing that the FCC's most recent setting of the contribution factor violated the Constitution as well as the law. And they make a number of different arguments. Some are what I would say are relatively simple to fix if they were to win, such as that the FCC has given too much power to the Universal Service Administrative Corporation. But the big question is, would a court agree with them that the way the FCC collects money to spend on universal service is unconstitutional? That is to say that Congress has essentially given the power to tax to the FCC, and the Constitution does not allow that. And the reason why that's so big is that's at the heart of the system. That's at the heart of what Congress gave the FCC the authority to do in 1996. That has been in place since 1996. And that is what funds what we used to think of as a high-cost fund. It has different names, but fundamentally deployment in rural areas. That is what has funded the E-rate, which has helped public institutions get the connectivity they need. And it has funded the Lifeline program. And what the court said yesterday was, we find this to be a tax. Now, they did it on a 9-7 vote. There were 3 Republicans joining 4 Democrats, and then all the 9 votes on the circuit were Republicans. But having said that, the 11th Circuit, which is a very conservative circuit, previously has ruled that the USF system is constitutional. The 6th Circuit, a very conservative circuit, had previously ruled that way. And so the Fifth Circuit is something of an outlier here in a very hotly contested decision. Now, there are many different things going on. There are many balls in the air. In a very kind of curious way, they did not vacate the FCC order. In other words, as far as I can tell, the FCC's order is still in effect. Money can flow in and money can flow out. That, by the way, is not a universal view. Some lawyers have told me, no, I don't think if the FCC tries to collect any money in the Fifth Circuit, people can go to court and say, no, you can't do that. There's an element of chaos here. But the big question to me is, what does this do to the future of universal service reform, which clearly needs to be done? With all due respect to Chair Pai, he kicked the can down the road, not talking about universal service reform. In his 4 years, the contribution factor doubled, which is a lot. And then as he was walking out the door, he said, oh, by the way, we probably should do something about universal service reform. But to be honest, and I guess in a bizarre way bipartisan, this commission under Chair Rosenworcel hasn't really done anything either. Instead, saying to Congress, this is your problem, you need to fix it, but not providing the intellectual or analytic leadership that I think Congress really needs to fix the problem. This makes it much more difficult to fix, because if you can't do the kinds of assessments, I'm sure all the listeners to your podcast understand, where the FCC says, here's the contribution base, here's what we need from that base, and here's how we're going to spend it. If you can't do the first two things, how do you have a program? If you remand it to the FCC, but there's no ability to collect money, what are you talking about? That's at the heart of the program. So there's a lot of uncertainty, and there's certainly a lot of uncertainty about what the current Congress will do in the sense of what they believe, but they aren't going to do anything. And so the question is, what does the next Congress do? And what does the Supreme Court do?
So for layman's terms, Blair, just kind of furthering the decision yesterday out of the Fifth Circuit, are they kind of kicking the can down the road with this decision, or are they sending it back to Congress to say, you guys need to figure this out? I'm a little confused as to what exactly the Fifth Circuit ruled on and kind of what are the next steps as a result of that ruling.
Well, the first thing I want to tell you is, if you actually read the 100, I think it's 130 or 107 pages, it's a long decision. And of course, there's a very vigorous dissent. If you read it, you will become more confused.
Okay.
In so many ways, it is not at all clear to me that the judges actually understood what they were writing about. And I will just point out, if you remand it to the FCC for a new order consistent with this decision, it would be as if you were to say, you Army, go to war, but we're not going to give you any bullets, no guns, no tanks, but really go fight a war. What are you talking about?
Yeah, right.
If you don't have the ability to raise funds, what does the Fifth Circuit think the FCC is going to do? So it's a very confusing thing. It's also confusing because you don't know what the Supreme Court's going to do. You don't know what the Congress is going to do. And of course, it's also confusing because who's going to be the chair of the FCC when January ends in 2025? And who's going to be in control of the House and control of the Senate? So it's a somewhat chaotic decision in a somewhat chaotic time.
Okay. And then thinking about the previous decisions out of different circuits that seem to be in favor of the current structure, in the grand scheme of things as to how this potentially could move forward, does that have an impact on the current situation, that there is some kind of precedent or ruling that says, hey, what we're doing right now is in fact okay?
Yeah. And I want to be clear. You use the word in favor of. I'm going to play lawyer here for a second. I don't think that's what the Sixth Circuit and 11th Circuit were saying. I don't think they said, gee, this is a great way to design a universal service program. What they said is it's constitutional. Congress did its job and the FCC is now doing its job. There was a certain kind of judicial humility in saying, yeah, it's okay. On the other hand, the Fifth Circuit displayed what I think is enormous judicial arrogance. But having said that, the importance of the Sixth and 11th Circuit is, number one, it tees it up for the Supreme Court to take the case, because there's now a split in the circuits. And the Supreme Court has various reasons to take cases, but one of the most important is where there's a split in the circuit that they have to resolve. Number two, you have the Supreme Court with two very conservative circuits essentially writing an opinion that the Supreme Court could adopt. Now, one of the things my years on Wall Street has taught me is you're really doing two things when you make a prediction. You're saying, here's what I think happens, but you're also trying to tell people, and here's my level of conviction. Because a lot of times you have to make a call, you have to make a prediction where you're missing a lot of evidence, right? So I'm going to make a prediction, but I really hate doing it before I read the briefs and before I've seen all the arguments and stuff like that.
Fair enough.
Having said that, I think that, number one, I think the Supreme Court will take it. Number two, I think there will be at least two, if not three, justices who agree with the Fifth Circuit. But I think a majority will agree, in part because I think that's where the law is, and in part because, in particularly, I'm thinking of kind of what you might think of in this court as the middle. Industry is fundamentally on the side of the regulators here. For example, the West Virginia v. EPA case, you had certain industry interests that were against the EPA. Interestingly, you had industry interests that were for the EPA. And this is the so-called major question doctrine. But here, industry is absolutely aligned with the FCC. And it's interesting because there are some people in industry who might benefit from the elimination of the universal service regime. There are a number of companies who aren't really in rural areas, and their rates would essentially go down, giving them some new pricing power. But I think they all know that there's a certain kind of karma in politics. And if you get rid of universal service, you create a certain kind of chaos. And they might not be the beneficiaries of where that chaos leads. And they would prefer the system they know to the system they don't.
Yeah, that makes sense. I guess then in the meantime, assuming this eventually goes to the Supreme Court and we've got a lame duck Congress session coming up, so probably not a lot's going to go on there anytime soon.
It's not just a lame duck. This House of Representatives is the most historically inactive, least effective House of Representatives I think the country has ever had. I mean, when you look at the number of bills that they have passed, it's almost non-existent. So it's not simply because we're late in the season. It's because the nature of the House of Representatives, and you could say the Senate as well, because they have to work together.
Wow. Well, Blair, listen, thanks for going through all of that. It's certainly a fascinating situation, a very important situation for a lot of our customers. So we'll be certainly watching this USF saga unfold, if you will, and hopefully in the future you can come back on and talk more about future developments, because we're certainly not done with this one. So before we wrap it up, I just wanted to talk briefly about what I originally requested you to be on the podcast for, which was a recent Supreme Court ruling, the Chevron deference ruling, because as I look at it as a layman, it feels like there's some overlap between that Supreme Court ruling and the USF program managed by USAC and the FCC. So maybe you could just kind of give listeners an overview on that. I mean, are we right to think about the overlap between that ruling and the FCC, and any other thoughts you have related to that particular Chevron deference ruling?
It's a great question. Where I think the common link is that this Supreme Court, by which I mean the Roberts Court, has over the last few years developed a jurisprudence of what we might think of as judicial supremacy in terms of executive agencies, independent agencies, in which they have put the courts in a superior position, and they've done it in a variety of ways. One very important case is West Virginia v. EPA, where they enunciated what they call the major question doctrine. I think they made it up, but they say there's a long history of it. We could argue about that. But it fundamentally comes down to, if the question that the agency is answering involves a lot of money or affects a lot of people, any court can say, gosh, we really think Congress needs to resolve that. Now, of course, Congress always had the ability to resolve it. And that essentially opens up an avenue to attacking any regulation, and particularly giving a very polarized judiciary and the ability to pick your location. People who want to challenge a ruling, conservatives who want to challenge something will go to Texas, and liberals who want to challenge something can go to Oregon. And there are various districts where everyone knows you can go. The next ruling is the one you just mentioned, the Loper-Bright decision. And that overturned 40 years of precedent related to Chevron deference. Chevron deference, interestingly, was a case where progressives were challenging the Reagan EPA, saying they didn't regulate enough. And the court said, we're going to defer to the EPA's own judgment of what the law means, as long as it's reasonable. And that's basically been the standard for a long time. And what they said in the recent case, the Loper-Bright case, is no. The courts are, they kind of say, equal to the agency, but really what they said is we're superior. We are the experts in what the law means. And so we can interpret it and just overturn anything. Now, there are some people who say, well, this is good for industry. But in the case of telecom regulation, I'm not sure that is right. where you have a regulator who is generally at odds with industry, and there are some who are, like EPA or OSHA, where they're trying to lower the third-party negative externalities, those costs, or they're trying to get industry to be more transparent so that markets work better. Industry might say, we don't like that. You can argue about the regulation, but there are some where it's like just industry versus the agency. But in the case of telecom, the FCC is often mediating disputes, whether it be about spectrum or USF or any number of other things between industry groups. And so, let me give you an example. In 1996, I was chief of staff at the FCC. Congress passed the Telecommunications Act. In 93, Congress gave us auction authority. We took those mandates and we said we want there to be more competition within wireless and more competition between wired and wireless. And we did a variety of things. We lowered terminating access charges for wireless to wired. We put in wireless number portability, very important for wireless competition. We put in spectrum caps in auctions. There were a lot of details Congress did not do, but industry fundamentally invested literally hundreds of billions of dollars to build new networks, had to have more robust competition and all of that. If this Supreme Court had been in charge at that point in time, we would not have been able to do any of those things because we would have been in court for 10 years. So, and the wireless industry would be much smaller. Probably the cable industry in terms of their broadband efforts would have been delayed. There are a variety of things that I could point out that depended on the FCC having the political and legal authority to do that this court is now saying, no, we're going to turn it over to hundreds of district court judges, all the circuits. It'll be chaos for a number of years, fragmented. And let me just mention one last thing. When the court enunciated the major question doctrine, a lot of telecom lawyers said, this is great because now we'll get rid of net neutrality because it's a major question, only Congress can do it. The problem with that argument is that if you're raising a major question offense against a regulation, you are conceding that Congress has not addressed the question. If you are saying that Congress has not addressed the question as a matter of the law of preemption, that opens the door to states doing it. So congratulations, you now have California regulating net neutrality. So look, the combination of the major question doctrine and the Chevron doctrine and what the Fifth Circuit just did, what ties them together is a certain judicial arrogance, in my view. They are enunciating a judicial supremacy doctrine in which they will be in charge, but they can't actually do anything. All they can do is veto things. So you're essentially crippling the ability of the government to act.
Yeah, gosh, it just seems like there's a bunch of landmines that have just been placed out there that, we have no idea if we're going to step on or, that just seems like a real mess. Blair, look, your insight, your perspective, your knowledge on all of this stuff is simply unmatched.
I'll take the compliment. Thank you.
A special thanks goes out to Blair for being on the podcast today. Like most legal matters, the devil is in the detail, and that is certainly the case here. It appears this case is headed to the Supreme Court, especially given that we have conflicting decisions in the lower courts. I guess the optimist in me would say that, given the opinions of the 11th and 6th circuits, which are known to be conservative, that the USF program is constitutional, and with the very close vote in the 5th Circuit, maybe all of this gets sorted out at the Supreme Court. But make no mistake about it, USF needs to be reformed, but what needs to stay in place is the critical support the program offers to rural America. Hey, thanks for joining me today, and a special thanks goes out to my fellow CoBank associates, Christina Pope and Tyler Heron, who make this podcast possible. Watch out for the next episode of the All Day Digital Podcast.
The information provided in this podcast is not intended to be investment, tax, or legal advice and should not be relied upon by listeners for such purposes. The information contained in this podcast has been compiled from what CoBank regards as reliable sources. However, CoBank does not make any representation or warranty regarding the content and disclaims any responsibility for the information, materials, third-party opinions, and data included in this podcast. In no event will CoBank be liable for any decision made or actions taken by any person or persons relying on the information contained in this podcast.